Welcome to Momentum for Change, Voices of the Missouri Movement. This is a monthly podcast produced by your coalition, and I am your host, Nora Mosby, a member services specialist at the Missouri Coalition Against Domestic and Sexual Violence. We hope that you enjoy this conversation coming to you directly from Voices of the Missouri Movement. Some episodes of Momentum for Change have conversations that include content and descriptions of domestic and sexual violence, which may be alarming or activating for some listeners. Please take care and visit the MOCADSV website or call our office to connect with supportive services. Welcome to episode 11 of the fourth season of Momentum for Change. This is your host, Nora Mosby. At MOCADSV, we recognize that survivors of domestic and sexual violence live complex, multidimensional lives. No two survivors have the same experiences, and resources available to support survivors. Healing and survivors' justice reflect this range of diverse experiences. One option available to survivors is to pursue justice in the civil courts. This gives survivors the opportunity to sue the person who harmed them, to seek accountability, and to find healing and empowerment through the civil process. We are joined today by Reed Martens, an attorney with Monsees Mayer in Kansas City. Reed is here to talk about his important work to represent survivors of sexual assault in civil cases. Reed, thank you so much for all that you do, and thank you for being here for this conversation today. As we're getting started, can you introduce yourself to listeners and let us know what you do at Monsees Mayer?
Well, hi, Nora, and thank you for having me on the podcast today. I'm excited for our conversation. I work out of our Kansas City office with three other attorneys, and we've got about 6 to 8 support staff with another 2 attorneys down in our Springfield office. And the primary focus of our practice at Monsees Mayer is the representation of victims and survivors of sexual assault. And as you said, this is through our civil court system, which the sole remedy is money damages to compensate for harm, or in the case of victims and survivors, unfortunately, lifelong harm. But it also serves the important purpose of holding those accountable, whether it be the perpetrator directly or institutions and organizations that employ them, enable them, or empower them.
And I could not agree more that accountability is such an important piece of the puzzle, and I can't wait to talk to you about that. But before we get into what these kinds of civil cases look like, I would love to hear more about your background. How did you get involved in practicing law, and how did you get involved with this work at Monsees Mayer?
Yeah, I'm very fortunate to be a part of the team at Monsees Mayer. I think that we've, I'm biased, but I think we have the best attorney team and support staff team in all of the region. We've got folks who are in it for the right reason. Yes, we got to make a living, but we're fortunate to get to cross paths with victims and survivors and try to turn a horrible, horrible experience, hopefully into a positive result and put them on a path and journey for healing and for success moving forward. Of course, just acknowledging the obvious, money can be a great resource to provide for someone that's been through that, whether it be for counseling or therapy or otherwise. But I started at this firm. It was my first job out of law school, or in law school, I should say. In 2014, I began as a clerk. I clerked for 2 or 3 years. They kept me around. I'm very fortunate for that. And I kind of worked up through being an associate, and then now currently am a partner at the firm. But I think to answer your question, how I got into the law, when I graduated high school in 2009, I had to make a decision of which way my career path was going. And I came from a family of car dealers. That was a pretty, difficult time for a lot of businesses, including car dealerships. But my family, my father actually lost his dealership at the time. It was kind of a government taking, if you will. And so I did a deep dive on that in terms of what was his option for relief. He was hiring attorneys, of course, at the time. But that was the first thing that comes to mind in terms of what sparked my interest, was how can I help my father? And then it broadened to how can I help others? And now I'm just fully embraced in this role, and I do believe it's my calling of how can I help others. It just happens to be more narrowly tailored to victims and survivors now.
Interesting. So it sounds like you have a true passion for service, as well as a passion for justice for survivors.
Right, absolutely.
So I would love to hear more about Monsees and Mayer and how did they come to specialize in taking on these cases to support survivors?
I think it's a little bit of happenstance, and it can be a dark topic at time. I hear so many people when we talk about our line of work, they say, "I'm sorry, that must be so hard," and it of course is, but I cannot emphasize enough how rewarding it is. It is the most proud work that I've ever done, and it makes me kind of emotional thinking about it. But the origin for us goes back around probably the same time that I began working at the firm. Not that it has anything to do with me working at the firm, but I think our managing partner, David Mayer, at that time, he was working on a case where he was representing five courageous women who came forward after they experienced um, abuse within the church. And there were so many issues in that case, legal issues, involving the statute of limitations, the claims that we could bring, ability to recover money through insurance proceeds. And to no surprise, David worked harder than I've ever seen him work on a case, and achieved an amazing outcome for those young women. And I think that was the jumping off point for us, is that there wasn't a lot of attorneys and firms working within this space in the civil
Hmm.
side. And, through word of mouth or otherwise, that result kind of got around, and we became kind of an expert overnight, if you will. And I think, right or wrong, a lot of people look to us for guidance on these issues. And we're always happy to talk with potential clients or clients and try to help them out. And so that's, from 14 years ago to fast forward now, or a little less than that. That's how we got up to speed.
Yeah, I can relate when you said that, you were getting a little emotional about it. I can definitely relate to that because when you're working to support survivors, these are real people's lives that as an advocate, as an attorney, you can have such a great opportunity to make a huge impact on, and you see that impact in your practice sometimes. And so it is truly meaningful work. And I so appreciate that you all did come to specialize in taking these kinds of cases. It's really important. And so as you talk about, you started with representing these five women in an abuse case involving the church. You also kind of specialize in taking other types of sexual abuse cases. So, can you speak to what are the different types of cases that you all have taken or will consider taking in the future?
Yeah. Yeah. I almost feel like I need to give a disclaimer because the list is long. Because as we know, abuse happens in all walks of life.
Hmm.
And whether it be abuse within the home, abuse within the healthcare setting, schools, boarding schools, summer camps, residential facilities, inpatient and outpatient treatment settings such as psychiatry, psychology, you name it. And I would just say within each of those settings, there's legal nuances that require us to sit down with the clients and make sure they understand the ramifications. But that is just a preview of the context that we've seen and handled cases.
Right. I mean, such a range of experiences that survivors had, as I was talking about in the beginning. Um, and this kind of abuse does happen throughout a person's life and maybe once or multiple times. And so, as you're talking to survivors who maybe experienced abuse in their childhood or many years ago, what are some just basic pointers you have around the statutes of limitations for civil cases in particular?
Yeah, that's usually our starting point. When I'll tell you, we talk with hundreds of victims and survivors every year, and we're only able to help a small percentage, or at least make a recommendation to a small percentage that it is in their best interest to have us take another step and investigate their case. And this is an important point, and I just want to emphasize this: that through our trauma-informed training and our staff and our attorneys, we do it every year. That's our consideration is we know that a victim or survivor is going to be re-traumatized if they go through this process. And so we need to balance that when we're analyzing their statute of limitation or some other factor to make sure that it's worth their while to go through and that we've got a reasonable likelihood that we can do good for them rather than do more harm than good in the civil courts. And so that, to come back to your question, that's where we start. And we've got to analyze, hey, look, before we go any further, we need to know, do you have a statute of limitation in Missouri or Kansas or wherever else it may be? And anyone listening to this should just understand generally, there are exceptions, but generally, for civil claims of childhood sexual abuse, that claim has to be brought before your 26th birthday. Your 26th birthday, and that's as it relates to claims against organizations and institutions, not perpetrators. If you're bringing a claim directly against perpetrators, you have a little more time. You have until your 31st birthday. But those claims against perpetrators directly are much harder to collect money in the civil courts as opposed to against organizations. And we can get into that, but it's kind of a long conversation.
And that's if in situations where the abuse occurred before somebody was the age of 18?
Correct. Good clarification, yes.
Do you also represent survivors of sexual abuse where the abuse happened when they were over the age of 18 as adults?
Yes, another good question. Their statute would likely be the general 5-year statute of limitation as opposed to the extended one we just discussed.
Well, thank you for that quick overview. I know there's a lot to be said about statutes of limitations, but I think that's really helpful as just a starting off point.
Yeah, right. Yeah, if we do our job, hopefully we can get the statute of limitation in Missouri extended well beyond someone's 26th birthday because we are just behind the times and we're behind the science.
Yep. And I know there's some legislation that's been introduced in the Missouri General Assembly, and we all hope that there's more momentum to come on that policy change as well. You mentioned trauma-informed representation, and I think one really important tenet of trauma-informed care is building trust with survivors. And one important way to build trust with survivors is to believe survivors, to believe what they're telling you, to believe what happened to them. So, can you talk about how you integrate that principle into your trauma informed representation or any other thoughts around building trust with survivors as you are beginning to work on these cases?
Yeah, really important issue, right? I think that through our training and our education with our partners, we understand that we can't assume anything. And what we need to know or what we need to understand and to preach and practice is that we need to thank any victim or survivor who's reaching out for us because it means they've taken a huge step in their life. They have chosen our firm, our attorneys, and our staff to share their story. And a lot of times, we're the first person they're telling. Okay. And so that's what I mean. Don't assume anything. It's our job to remind them of the courage that they have to come forward, to thank them for choosing us to share. And the other thing we don't assume is that we're going to get their trust. We know we need to earn their trust. It's not going to happen the first phone call. It may not happen the first meeting. It's probably going to take the life of our representation to earn their trust. But it's important because when we turn to them at an important crossroad in their case, maybe it's a settlement offer. Should I take this or should I not? Or maybe the decision of whether to wage trial and go to trial. Should we go to trial and take that risk or should we settle? That conversation only works if we have earned their trust. And that is crucially important for us.
Interesting. Okay. Well, thank you for speaking to that. I think that's really helpful to understand. And as we're talking further about just civil options for survivors, I want to unpack kind of what that representation looks like. And so when you're talking about what pursuing a civil case would look like for survivors, how do you present that as an alternative or maybe an addition to a criminal suit?
Yeah. Education is first and foremost because a lot of folks don't know that they have a civil remedy. And I think education starts on the front lines with advocates, prosecuting attorneys, law enforcement, to make sure that in their conversations, they let a victim or survivor know that, hey, maybe you need to talk with a civil attorney as well, because that's an option. And we've worked hard over the past 10 years. We've generated and authored, pamphlets and booklets, and we speak and, really getting the word out. So that's first and foremost. Second is to educate on the interplay between the criminal and civil process. You don't have to have both at any point. You can have a criminal case without a civil and a civil without a criminal. Okay. While there are parallels and there are certainly some things to be gained in the civil case from the results of the criminal case, it doesn't mean that one is dispositive of the other. Let me give you an example. Let's say that there's a criminal prosecution involving a sexual assault, and the case goes to a criminal trial, but the perpetrator is acquitted. Well, that doesn't mean that you don't have a civil case, okay? It may impact your analysis a little bit. It may not. But on the civil side of things, you have a completely different burden of proof, a much lower burden of proof. And we've all probably heard the term through television or movies. In criminal cases, prosecutors have to prove their case, their prosecution, beyond a reasonable doubt. Well, in the civil case, we have a much lower burden of proof called a preponderance of the evidence. And so I think most people you might be thinking right now, this is the O.J. Simpson situation, right? He's acquitted criminally, but then the estate later brought a civil case, and he was found liable. Okay, that can happen in our situation too. But I would just add, and I say this because I always want to encourage victims and survivors, or at least educate them so they're not, deterred in pursuing a claim, is that even if there wasn't a police report, or maybe there was a police report, but there was a decision not to prosecute, or maybe a decision to prosecute, but later the charges were dropped, it doesn't matter. Talk with a civil attorney who is experienced in this field to get a complete and separate evaluation on whether you have a civil claim. It's a different analysis.
Yeah, Reed, I really appreciate you saying that a lot of survivors just aren't aware that these kinds of civil cases are an option. And that's why I was just so excited to talk to you today, because I also really want to get the word out there to survivors and advocates that this could just be another course of action for survivors to take to receive justice. Um, and I think meet the goal of empowering survivors. And so, what would you say about this legal option and its role for empowering survivors, or maybe even supporting survivors' healing process?
Yeah, it can be everything. And I say that after representing numerous victims and survivors who came to us after they felt that the criminal justice system failed them in one respect or another. Maybe it's because their case wasn't charged, maybe because there was an acquittal, maybe it was just simply because they felt like they weren't kept in the dark in terms of the decisions that the prosecution was making. And I think the reality of the situation is that, and this is an educational component too, is that the criminal system, the criminal justice system, isn't designed for the victim. It isn't designed to compensate the victim. It is designed to punish the wrongdoer and deter others from committing crimes. And so I think it's a kind of a breath of fresh air when they're exposed to the civil process and they come into our firm, they meet with our attorneys, and they realize that our job is dedicated 100% to them, and a successful representation is exclusive to what they want and how they see it in their eyes. And that's the only thing we're after, is how can we help you, and what does success look like to you?
Okay. Well, that is such an important clarification, I think, in terms of understanding the difference between the criminal and civil justice system, that the criminal is more punitive, and certainly that can be a really important avenue for survivors to pursue justice and pursue healing, and they can have success in that. But I think we're here today to encourage people to also think about civil litigation if and when maybe that criminal case isn't successful. Um, And that I really am glad you also brought up that standard of evidence and that there's a different standard of evidence for civil cases. When I was working with survivors and there was an acquittal or the case didn't move forward, I would always say, not guilty does not mean innocent. It doesn't mean it didn't happen. But to also be able to have another tool in our toolbox and say, but what about maybe talking to an attorney about a civil case as
Right.
a way to pursue justice? And when we talk about justice for survivors, we're often also talking about accountability for the harm that was done to them, accountability for perpetrators. So while the civil process, as you have spoken to, does not really focus on punishment the way that criminal proceedings do, there is a level of accountability in the civil process. So can you talk about what that accountability looks like or what role that plays in the civil process?
Yeah. Yeah, you're spot on. And instead of, guilty, we call it liable, right? And that's how that's accountability in the civil system. And here's what I would say to that is that you have to acknowledge that the civil justice system isn't perfect. It's imperfect, but it's the best system in the world, and it's the system our founding fathers, came up with. And this is something we talk a lot about at trial with juries. But if we're after full justice, and it's full justice is in the civil system is placing enough money on one side of the scales and it being enough money to balance the harms that a victim has experienced and may experience for the rest of their lives. Okay, that's full justice in our minds, and that's what we try to achieve in the civil system. Now, this is kind of the tongue-in-cheek comment, but like if true justice doesn't exist, because we know what that looks like, and even dating back to to the biblical days, or if it's an eye for an eye, right? And that doesn't exist, and we don't want that to exist. But the next best thing is full justice. And again, while the process isn't perfect, I think it's the best system in the world. And how we get there, even though it can be an interesting or kind of weird concept to some, is through money.
Yeah. So I was interested when you were talking earlier about going after maybe organizations that should have protected a survivor or maybe taken steps that weren't taken in order to prevent sexual abuse from happening. Um, so what does accountability look like at that organizational level? Is your hope that potentially these kinds of cases could encourage organizations to take steps to protect people within their care in the future?
Yeah. Yeah, so we have this conversation a lot with our clients, and we try to make clear that the only thing for certain that we can strive to accomplish is the recovery of money, because that's the only thing the civil system expressly authorizes. But certainly there are surrounding motives that we hope are accomplished, and one of is you hit on is if we can make the community safer through cases like these, whether and just spread awareness, then we've accomplished an even greater good, and that's our job. um, I always draw the parallel, attorneys who handle defective product cases. I think those plaintiffs attorneys may have the mindset that if we can get the manufacturers to design a safer product, then and eliminate the hazard, then we've made the community or consumer safer in that sense. And certainly we try to do that at an organizational level. And we always ask our clients too, like, hey, if you've got things that you want to accomplish beyond the recovery of money, such as institutional change, the addition of policies, you let us know. Let's have that conversation, because we will push that all day. We can't guarantee it, but we just need to know up front, because if we ever get to a situation where we're talking about settlement or resolution of your claim, that needs to be an included term that, hey, look, in addition to payment of money, we would like to see an enhancement in your organizational policies, whether it be regarding your hiring and screening criteria or your supervision policies. So those are alternative. Those are other ways in which we can accomplish that end goal.
Oh, Reed, the more you talk about this, the more exciting I find this to be. This is wonderful to hear. So I know you've got attorney-client privilege with the cases that you represent, but do you have any examples of that kind of institutional change that you are able to share with listeners? And it's okay if you don't, I understand.
Um, yeah, good question. I think I can kind of paint it with a broad stroke. I would go back to some of the examples. But at the end of a settlement, typically there's a release agreement. It's kind of the document that says, hey, in exchange for payment of this money, Jane Doe can't bring claims against the organization. And in that document, many times through negotiating and bargaining in those terms, we have included provisions that relate they're industry specific. So whether it be a school, a daycare, or otherwise, we probably have gotten in discovery some of their documents, their policies, and we'll sit down with our clients or our experts at times and say, what needs to change here? What needs to change in this policy so that a child at their institution isn't harmed in the future? And so we have been able to do that. I know that's general, but
No, I
hopefully
love
that.
that example. I have to say, at MOC ADSB, we are big believers in policies and procedures because we know what a difference it makes in terms of impacting survivors' experiences. So thanks for sharing that example. Can you talk to us more about the process? Like if you're able to take a case, what do you tell a survivor in terms of what they can expect, maybe the duration, how long it takes, that just kind of the nuts and bolts of it.
Yeah. Yeah, I would say I will probably not state it as succinctly as there's some materials on our website and videos that we have done that lay out what is the process of a lawsuit. And then, of course, once a client retains us through our case management software, our clients can actually download an app and monitor the progress of their case. And within that app, there is kind of an informative section that lays out what you can expect during the course of your lawsuit. But for the purpose of our discussion here, I'll try to hit the high points. Once we are retained by a client in terms they've formally signed our client agreement, from there's typically a 60 to 90-day investigative phase that involves us collecting records that we might not already have, whether it be treatment records, law enforcement records, or otherwise. At the conclusion of the investigative phase, we typically sit down with our clients and discuss our recommendations, whether it be to file a lawsuit, before you file a lawsuit, send a settlement opportunity letter in hopes of resolving your case without ever having to go through a lawsuit. And sometimes if, just to be transparent, our recommendation is not to proceed. And it's okay to have that conversation because we know that, the best form of trauma-informed communication is being honest and open and upfront. And even if it means delivering bad news, it's better that if our clients know that upfront as opposed to taking them through, a very taxing civil litigation process.
Yep, absolutely.
Yeah. So at that point, we're at a crossroads. Sometimes we're able to resolve cases before you jump into a lawsuit, and that's great. I think you should always explore that if the client wants to and if it makes sense. If you do file a lawsuit, typically we say that it's usually about 12 to 18 months before you can get a trial date. And that's what you're working towards at all times during your lawsuit is you're working to that trial date. It's important that you prepare the case from day one for trial. We think that puts the client in the best situation to either maximize their recovery or be able to evaluate whether they want to go to trial. And certainly there are risks inherent in that. Trials are hard on attorneys, but we know they're even more hard on clients. They're filled with a lot of stress and anxiety. And then at the end of it, you turn your client's story over to members of your community to make a decision, and you just never know what they're going to do. But I'll just say to kind of close this up, during that 12 to 18 month lawsuit I was on file, there's a lot of work by the attorneys. Discovery is taking place, which means we are collecting documents. We are taking the depositions of various witnesses who have information about, our client's case. And then, of course, we typically would retain expert witnesses. Those may be expert witnesses who are supporting your client's case in terms of what did the organization do that was wrong, and then also have expert witnesses who support their damages or the harms that they've, dealt with. And these can be treating therapists, but they can also be, psychologists or psychiatrists that we retain that perhaps our client does an evaluation with, and then who would testify at trial and be an advocate for them.
Wonderful. So These cases really are complex and can take quite a while to reach a conclusion. I was thinking that oftentimes, an offender may have harmed more than one person. How common is it for you to take on a case and then discover that there's more than one victim or have more than one victim become involved in the process?
Too many times than I would like to experience.
Yeah.
And we see it quite often of multi-victim situation in organizations and institutions. Some examples that kind of come to mind are summer camps and boarding schools. And I think in those, and even schools, and I think the common thread that we see in those instances a lot of times are systemic. You talked about the importance of policies and procedures. We certainly agree with that. A lot of times it's the lack of those, or even if an organization, at face value does have robust policies, it's a failure to enforce and to follow. And along with that, because of the failure to follow the policies, you may see, red flags that go unnoticed or ignored. And that's what gives life to a perpetrating, individual to carry out the misfortune on more than one individual.
You also mentioned expert witnesses, which I think can have a lot of leverage in these kinds of cases. And so I wonder if you could speak to how often do these cases settle? Have you found that having expert witnesses help encourage a settlement, or anything else you'd like to say about expert witnesses?
Yeah. Um, the odds that cases settle are pretty high. I mean, I think that we know that I would say even greater than 95% of civil injury cases do resolve before a jury trial. Okay. Now, my disclaimer is, and we always tell our clients, that doesn't mean that your case is going to settle. There are a variety of factors that affect that, but there is so much risk inherent on both sides that I think that risk and uncertainty of a jury trial drives settlement. And that can be, settlement can be beautiful. You just got to have the right mindset going into it. And I think that, for this industry specific or, victims and survivors, that can be a desired outcome. But, sometimes it's important for our clients that, accountability in their eyes is presenting their story in a public trial and having a jury determine accountability. So it can look
Yep.
different. And then, yeah. And then in terms of expert witnesses, I think it's getting making sure you talk with civil attorneys who are connected with the right experts can add value to your case. But otherwise, I would say, not just generally having them. I don't know that drives the value, but having the right one certainly can.
Yep, that makes so much sense. And I love that you said settlements are beautiful, but also for some survivors, having their day in court can also be really beautiful. So it just really depends on, that survivor's situation and what their interpretation of justice is, I can see. So I'm glad you
Yeah.
spoke to both of those points.
Yeah, we love being trial attorneys, and it's got its ups and downs. But like I said, it's very proud work. But all at the same time, especially when it makes sense for our clients, we are okay being settlement lawyers at times too, and that's just how it
Right.
plays out.
Makes sense to me. I get it. So after you've gone through this process with survivors, and you achieve a kind of a conclusion of a case, what kind of results have you had that you can speak to? And what kind of feedback have you gotten from survivors about going through this process?
Um, you know, I think it's a good thing. I've only heard good feedback uh, from most of them, and that's not just for me. That the feedback that we get, and I'm sure somewhere we've got some reviews that are out there that people can see. I think we've really set up a culture that uh, prepares our clients prepares their expectations and sets them up for success. And that's all we want. And at the end of the day, like I mentioned earlier, successful representation is really based upon what each client desires, right? Um, in terms of settlements or results, verdicts, otherwise, um, for one reason or another, a lot of results in this realm become at least confidential as to the amount. And that's, people look at that differently. It's up to our client ultimately, but it can be a good thing.
Mhm.
We always make sure our clients retain their ability to share their story, because that's a really important piece of their trauma journey, right? Is sharing their story. But there's the piece about it being out there, how much money they received. Again, we're just not certain in a lot of contexts how that's beneficial to our client, because we've seen instances where people, hear about a settlement, and you may not have heard of them for 10 years, but they're coming to you trying to befriend you and ask for money. And this could be someone in your family too. So, um, while, each settlement in this instance depends upon a variety of factors, there are resolutions in these cases that can be for hundreds of thousands of dollars, millions of dollars, tens of millions of dollars. It just really depends on the case and what the client wants.
And like you said at the beginning of our conversation, you're talking to survivors about kind of what would be required of them throughout this process, and they're making a decision that this is worth it as they're going forward.
Exactly.
So that brings me back to this trauma-informed approach that you all take at Monsees and Mayer, and that you all are training all your staff on a trauma-informed approach. So can you tell us more about what this training looks like and how this training impacts your interactions with survivors?
Yeah. And just to be clear, we don't do the training. We typically bring in a partner agency that comes in and does the training every year. They do a phenomenal job. We work with some local groups here in Kansas City. And I can't tell you how fundamentally different we communicate with victims and survivors after we started this training. I would say, I don't know, 6 or 7 years ago. And it starts from the very first conversation, like you said, which is starting with, I believe you. And, I may not ultimately have a recommendation that you're going to like, but I believe you and I want to be a resource for you. It's also important to let them know up front that, hey, look, if you want to meet with us, we'll do it on your terms. We'll come to you, or you can come to us. Maybe you don't want to meet in person. Maybe you want to do it via Zoom, or maybe you just want a phone call. And you got to explain these options and make sure that they know that this is their case and they're in charge. And we're just here to, walk with them down this path. And then I think getting out in front of the elephant in the room, which is probably the scariest question, is, that a survivor is thinking in their mind, which is like, do I have to talk to these people about my abuse?
Hmm.
And that's why in the first conversation, we will tell them and just say, hey, look, there may come a time or a point or a place where we need to have that conversation. We're only going to have it one time, and it's not going to be right now in this first conversation. And that's part of earning their trust, right? We've got to work to that point where they trust us enough to share, the details of their abuse. So those are just
Yep.
some of the examples that, our trauma-informed training has taught us and that we try to employ in our practice.
Wonderful. Well, so good to hear about that. And yeah, it sounds like you all are really taking steps from that very initial meeting and then throughout any additional contacts you have with survivors. And so it does really seem like that's a beneficial training that your staff has undertaken. So I think one issue that comes up for a lot of survivors is that they think about getting an attorney to pursue a civil lawsuit and are concerned about the expense. So can you talk a little bit about how you describe the expense to survivors, and what some of the initial out of pocket expenses are for someone who is looking into pursuing a civil case?
Yeah. That is the beauty of the way that our profession is structured, is that plaintiffs' attorneys like ourselves, like our firm, we work on a contingency fee. And as part of the contingency fee, the law firm fronts all costs, all case expenses, so that our clients, many of which they can't afford representation, they never have to pay anything out of their pocket. And that holds true even if we spend tens of thousands of dollars or hundreds of thousands of dollars on their case and we're unable to secure a recovery. That is the risk that we, as a law firm, take, and we would be responsible for those expenses. The only time in which our expenses, our case expenses are reimbursed is if we're successful in obtaining a monetary recovery for our client. Same thing goes for our fee, is that the only time we earn our fee is if we are successful for our clients. And that fee is taken as a percentage out of the recovery as a whole after case expenses are first deducted.
So it sounds like there's no initial out-of-pocket expenses. It's really just on survivors to decide if kind of the emotional toll of going through revisiting this trauma is worth it or not. And that is where their decision really lies.
Exactly. It's a big decision, and we understand it's probably the most important decision at that time in our clients' lives. And so, yeah, it's great. It's the way that it's set up. It allows us to invest in our client's case. Our interests are aligned. Obviously, the better that we do for our clients, the better we do as attorneys and firm. But there's a lot more, in terms of to consider emotionally than just the finances.
So we've covered a lot of ground about what the civil process looks like for your clients. Is there anything else kind of foundational about these civil uh, litigation of sexual abuse cases that you wanted to be sure to speak to?
Um, I don't know if it qualifies as foundational, but one component that we get a lot, we covered one, which is, hey, what's the difference between civil and criminal? And then the second that I think is just worth mentioning is, where does the money come from?
Mhm.
Because a lot of times I think people reach out to us and think that, their path is going to be exclusive to suing the perpetrator directly and hoping that the perpetrator has the means to pay for a settlement or for a verdict, right? Well, in practice, that's not the way it works. On the civil cases, most oftentimes you're actually looking at whether or not the perpetrator or the organization or employer is carrying insurance. And it's that insurance policy that really provides a foundation for the potential for monetary recovery. And we could spend a whole nother hour discussing the nuances of insurance coverage and how and when an insurance policy applies to a case relating to sexual abuse. But I just wanted to kind of touch on that's 99% of the times that is where recovery comes from on the civil side.
Yep, that's super helpful to hear. Thank you. So if we have listeners that are thinking about maybe contacting Monsees Mayer about their own situation, or if we have listeners who are advocates and talking to survivors about referring their case to Monsees Mayer, how would you like that referral to be made? How can people access your services?
Yeah, in this day and age, online, whether it be you're accessing from a computer or your phone, we've got an online submission, portal or option available on our website. Of course, we do include our attorney. Each attorney has their email listed on our website, and you're more than welcome to call our direct number or email us individually. That direct contact is totally fine with us. And it's also okay for you to call our office directly. Even our intake specialist is trauma informed and knows how to communicate with survivors. And so, going back to our earlier theme, we want to make ourselves accessible, but also accessible in any form that a victim or survivor would be comfortable reaching out to us.
And what can you say about the privacy that a caller might have as they're initiating contact with you all to discuss their case? Are there any kind of confidentiality protections they have as they're disclosing what happened to them?
Yeah. Yeah, the utmost privacy. I mean, I guess as much as we can guarantee, because even a first-time caller, before they've retained our firm, they're entitled under our rules of professional conduct to attorney-client privilege, just as if they were a client. Okay, so consultations are not only free, they're confidential.
Love it. The more I hear about this, the more I like Reed. This is just great to hear. And you mentioned your website, which does have, in addition to contact information, there is just a wealth of information on your website. Can you talk about some of the resources available on your website that people might be interested in pursuing or checking out?
Sure. Yeah, we try to keep it updated, whether it be writing articles, blogs. You can find that on our homepage. We also update our frequently asked questions page. this includes not only written content, but we try to stay up and shoot videos, short videos. We know that, I don't know that they're on TikTok or anything, but we know that's a extremely important source of information. Short videos that are informative. We also have, I think, available in e-version is our handbook that sets out to seek or to answer a lot of the questions that we've gotten over the years from victims and survivors. You should be able to access an electronic version online, but you could certainly also request hard or print versions with just a simple email to me or our office.
Yeah. So I encourage people to check out that website, and we will link your website in our show notes, Reed. So, in addition to your work representing survivors, you're also very active in the community, and you have testified in the Missouri legislature on issues such as the statute of limitations. So, can you talk more about your policy work and why that's important to you?
Yeah. As we mentioned earlier, I mean, Missouri is behind the times, looking at the nation as a whole and other states in terms of where the statute of limitation stands for victims of childhood sexual abuse. The current statute is age 26, and we know from research and science that the average age of disclosure in adults is age 52. So it's simply unacceptable. Missouri needs to get with the times. And that's been a primary focus the past 3 years. Myself, along with my law partners, Ryan Frazier and Bobby Thrasher, you're going to find us in Jeff City during the session doing what we can. And sometimes we testify, sometimes we're there to answer questions or to support our clients or other victims and survivors as they provide testimony. So super, super important work. We've gotten great help from other attorneys and partners in the community. It's not us. We're not even, a little bit. There's so many other people, organizations like the coalition and otherwise, who are really the ones on the front lines doing the work. We're just here to fill in where needed.
So, as you're preparing your testimony, are there any kind of points or resource citation or research citations that you find are particularly effective in moving policymakers?
Well, we haven't been successful yet, so I guess I haven't found the right recipe. But I feel like every time I prepare my testimony for a hearing, which I do prepare, as I sit back and listen to the testimony that comes before me, whether it be in favor of or in opposition to, I end up changing completely and just trying to pivot, on the move and make sure that I'm conveying the right message to our legislators. What needs to be said. So.
Well, fingers crossed. Hopefully, we'll see some positive movement in the right direction.
Yeah. Yep. And look, I think that we have seen momentum in previous years. We've seen these bills passed, at least through the House, unanimously that would affect statute of limitation reform. We need to get them. We need to get them either to the Senate earlier in the session, or I know they'll be pre-filed in the Senate, and we're getting a lot of. It's a bipartisan issue, so we need to get support on both sides and get it through both houses. But even as last year, we did see some positive reform, and that relates to Trey's law that was passed that puts a prohibition on the use of non-disclosure agreements in sexual assault cases. So, look, I think that the trend is in the right direction.
Yeah, I agree. It's a bipartisan issue, and so hopefully we can get more support on both sides of the aisle for the statute of limitation issues. Anything else you'd like to say about your policy work?
We'll keep going. There's a lot of work to be done.
Well, well, thank you for your work in that arena. It truly is significant and important. In addition to your work in the community, you also serve on the Missouri Coalition Against Domestic and Sexual Violence's board of directors. Thank you. Can you speak to why that service is important to you? You're very busy, and yet you're taking time out of your schedule to support the coalition. So, why is that important to you?
Yeah. First of all, I'm very fortunate when the coalition and Cheryl reached out to ask me to be on the board, and I think I'm in year 2 of my 3-year term. It's been eye-opening to me, and I think that what the reach of the coalition is significant, and I didn't realize until I became involved with the board how far-reaching it is, not only in terms from a policy standpoint, from an advocacy standpoint, from an agency standpoint. A lot of my fellow board members, are certainly at the agency level or run certain agencies, and I think my role as an attorney on the board in this field is to support them in any way I can. And certainly at times I'm reviewing, proposed policy or otherwise. But I think that that's where I'm coming in now to understand is our job is certainly when we're at the office or in the courtroom, we're advocating for victims and survivors, but that's just the tip of the iceberg. And we don't get there without organizations like the coalition and all the agencies that it supports.
Absolutely. And you're having such a huge change on survivors' lives. But then I think there's so many opportunities to have such a huge change within the whole state of Missouri through your work at the coalition. So I'm so glad you've taken that on. Do you want to say anything about your involvement with local advocacy organizations? There's some great domestic and sexual violence advocacy services in Kansas City, Springfield. You represent survivors from all over the state and in other states as well. So, any thoughts on partnering with local advocacy organizations?
Yeah, generally, I mean, we couldn't do it without them. Couldn't do it without them. Up here in Kansas City, we work with the CPC, Child Protection Center, MOXA, and then in Springfield, our office is actually right next door to the Children's Advocacy Center. I know they're moving soon, and we'll hope to keep that relationship going. We're sad to see them go as neighbors. And then, on the Kansas side, the Sunflower House is a great resource, but they are the front lines for victims and advocates, and sometimes, or victims and survivors, and sometimes when they reach out to us, frankly, what resource and services they need, we can't provide them. And so to be able to make direct referrals to those partners is crucial. But establishing rapport and a relationship with them so that they trust us when we make those referrals so that we can get victims the help that they need immediately, whether it be an advocate to go down and support them while they make a police report, therapy, a protective order, you name it. That comes and such before any work that we can do.
Yes, that makes so much sense. So it's really that comprehensive approach to services. There's things that you all can do at Monsees Mayer, and there's things that local advocacy organizations can do. And working together, you have that comprehensive wraparound approach to services.
Right.
Speaking of wraparound, as we are wrapping up, um, do you have any final takeaways that you want to speak to about your work to represent survivors of sexual abuse?
We've covered a lot of ground today, and I would just kind of here's my parting thought is if you've been abused as a child or as an adult, consider, and you haven't spoken to me about, consider the conversation we've had today and how we may handle and advise. Remember that it's confidential. It's a free consultation. And here's one of the worst parts about my job in this field is telling someone on the phone or in a meeting that they're past the statute of limitations. And it might be by several years, a decade or more, but I've also had the hard conversations when it's been by days or months. And oftentimes they just weren't ready in their own journey to share. Okay. So hopeful in this conversation that people understand when that time limit is, that they have a little bit more understanding that it's okay to come forward and have this conversation just to find out for themselves. Because that conversation will never get easy when I have to tell them that, hey, look, I'm sorry, under our current law, there's nothing I can do because you're beyond the statute of limitations. Mm-hmm. In our world, a lot of gray area exists where we can argue a respective position and we're uncertain of the answer. But one of the few bright line rules is that time limit, that statute of limitation. And if you're beyond it, you can't do it. So if you're thinking about a claim, be aware of the statutes, talk to an attorney, get as much information as you can so that you can make the best decision for yourself. And maybe that decision isn't pursuing a case, and that's okay too.
Yeah. Well, thank you for leaving us with those final thoughts. Reed, this has been such a helpful conversation. I just appreciate you. I appreciate the work that you do at Monsees and Mayer. I so appreciate the work that you do throughout the state of Missouri for positive policy change and on the coalition's board of directors. So just thank you for your time today. This has been a very helpful conversation.
Well, thanks, Nora, and thank you for the coalition's work. We couldn't do it without you.
And thank you, listeners, for tuning in. We certainly appreciate it. Please tune in next month for a new episode of Momentum for Change. Thank you for joining us. This has been a recorded conversation now available in both video and podcast formats. A video recording of this episode is available on the MOCADSV YouTube channel under the Momentum for Change playlist. Please subscribe to our YouTube channel in order to receive new episodes in your YouTube feed. You can also find all of our Momentum for Change episodes available to stream on Spotify or wherever you find your podcasts. Momentum for Change is a podcast produced by MOCADSV with post-production support provided by Tim Stillings and promotion by Adrian Maddox. Again, I am your host, Nora Mosby, and we appreciate you joining us for this episode. Thank you again, and we look forward to seeing you next month.